bottle of vodka and consumed the entire thing in front of the real witness.
What?
Yes, Sherman. That's what happened.
I don't care who you are, what color you are, if you're a small farm animal, if I find that you're using, but if you don't have anyone to pony up $5,000 to $10,000, you will be stuck like Chuck until this case is.
That witness report you just heard, a woman downing an entire bottle of vodka right in front of the witnesses after crashing her car. It sounds like a desperate legal tactic, but for Carol Lopez, the nightmare was just beginning. In this Texas courtroom, Carol faces a judge who has truly heard it all. This isn't just a simple accident. It involves a defendant who allegedly couldn't even keep her head up for the police during the investigation. Was she really downing chocolate vodka like water to mask her guilt? Or was she already dangerously over the limit before the impact? With a $10,000 bond on the line, Carol is one mistake away from being stuck like Chuck behind bars. To see how experienced judges dismantle these standard courtroom excuses and spot the lies most people miss, hit that subscribe button for more daily cases. Let's head back to the very beginning of the case.
All right, you are Carol Lopez.
Yes.
Miss Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Thank you, Judge. On March 26, 2025, an officer was dispatched to a crash on Antoine Drive in Orange County, Texas. The officer learned that an unknown party called 911 at the time of the crash. It was informed by another officer who arrived on scene that the observed defendant being treated by ambulance. The officer informed the other officer that the defendant had already been transported to receive medical care. After stroke with the real witness, who stated that the defendant was assaulted and struck the witness's vehicle, causing damage. The witness stated they observed strong odor of alcoholic beverage committed from the defendant, and the witness came in contact with the defendant. The witness stated that the defendant was still in the driver's seat at the time of their interaction, and that it was clear that the defendant was intoxicated. The witness reported that the defendant had slurred speech, was incoherent, and not making sense. The police stated to the witness, "I don't know where I am." The witness reported that being called, the defendant cell phone crashed, and immediately after that call, the defendant grabbed a bottle of vodka and consumed the entire thing in front of the real witness.
What?
Yes, Sherman. That's what happened.
She took a bottle of vodka and consumed an entire bottle of vodka in front of the will witness?
That's what I have here, man. The real witness noted that the defendant drank the alcohol bottle as if the defendant was drinking water.
Just when you think you've heard it all, man. I mean, really.
The officer observed an empty bottle of chocolate vodka, and then went to the hospital to make contact with the defendant. The officer observed the strong odor of alcohol beverage from the defendant, observed the defendant have slurred speech and glossy eye. The officer read the DIC form for the defendant when the defendant became coherent, and it proceeded to a breath test and blood test. The hospital discharged the defendant, and the defendant was transported to the Joint Processing Center, but was unable to perform the state arrest for sobriety test due to the defendant's failure to follow instructions and to keep the defendant's and the inability of the defendant to keep her head up. The officer took the defendant's failure to follow instructions as a refusal. The officer was unable to get the defendant to stand upright to perform HCN, and due to the defendant's physical conditions, the officer did not ask the defendant to perform walking turn or do a stand. The officer concluded. The officer offered the opportunity to provide breath and blood. The defendant declined to provide breath or blood, and the officer proceeded with a residual search warrant for the defendant's blood. The officer was advised. The officer was advised the blood would be ready in 2 to 3 days. The officer noted that. That's all I have.
Do you have blood back or no?
I do not. I'm not sure if that in the is referring to. The warrant was presented to the hospital, Your Honor, and a nurse advised that the blood is ready for 2 to 3 days. The officer.
Do you have any pride to your guys?
There was one in Caldwell County on the semester.
License?
Licensing. No,
This is who, Judge?
It's not on docket. I have to give you a case number. You ready? 255-7402.
Thank you.
If you speak English, right?
Yes.
If you have a problem with alcohol or drugs, now is the time for you to address it. Because stop. There's nothing that you can say at this moment. I'm warning you now, because this is the only one that you're going to get. I will do everything in my power to protect my city at all costs. I don't care who you are, what color you are, if you're a small farm animal. If I find that you're using, it's not going to go well. Do you understand?
Yes, sir.
Now is the time for you to try to get any help if you need help, because I don't know you. I've never met you before. All I know is what they're telling me. And if that's in fact true, now is the time for you to address it. I am going to put a monitor on your ankle so I know that you're not consuming alcohol at any time. I will not entertain any excuses like it's mouthwash, it's a tequila lollipop, hair dye. I've heard it all, and excuses mean nothing to me. If you consume, it's not going to go well. Because of, I don't want you in the car driving. You're not allowed to drive. Do you understand?
Yes, sir.
If I find that you do, it's really not going to go well for you. I am putting now a restriction on your license that you are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught, and I'm sending this notice to DPS, so everybody, every officer in this state knows, if they pull you over and they don't see an interlock, they will take you to jail. Do you understand? And then you and I will have problems. Just don't.
Judge, this is Carol Lopez first.
Yes, ma'am.
And then you said no driving?
Correct.
Thank you.
And then a scram, please.
Yes, Judge.
You have the ability to hire a lawyer, ma'am. We will give you an application. You missed court once. A warrant is now in effect for you because you missed court the first time. I will reinstate your bond now, but this is the only get out of jail free card that you get. If you miss court again, you violate any of these conditions, you will stay with me. And I don't know who you have in this life, but if you don't have anyone to pony up $5,000 to $10,000, you will be stuck like Chuck until this case is over. Do you understand? All right, come up. We'll have you sign this. I need you to fill an application. Deputy Miranda's going to give you an application, and we'll go from there.
Judge, I actually no driving issue. Her license is out.
Carol Lopez narrowly avoids jail today, leaving with a reinstated bond and a strict ankle monitor. But did the judge go too far with those farm animal warnings and that $10,000 price tag? Drop a comment below, Team Judge or Team Carol. Was this necessary tough love, or was it just too much for a first appearance? If you found this case wild, hit that like button. Share this video with someone who needs a reality check on courtroom drama.